Resolution of 5 Emirates by the Kano State House of Assembly and the subsequent restoration of Emir Mohammed Sanusi II has dominated headlines for days. On Wednesday, the Chief Justice of Nigeria summoned the Chief Judges of the Federal High Court and the Kano State High Court over conflicting orders issued by both courts in the saga. The confusion has led to questions on whether electronic recording of court proceedings could help. Let's bring in a former chairman of the Nigerian Bar Association here in Abuja, Folarin Aluko. Good to see you and thanks for your time. If you've ever been to court, I've been to court and I see how they put everything in longhand, and this is 2024. And now we're getting to see what this would mean to the extent that you can approach a particular court within even the same jurisdiction without having that information documented, perhaps in an intranet that will give the next judge an idea that this is already before another judge. Yeah. So, but again, welcome. Let us in on technology. You use technology quickly, by the way, the NBA in your elections, not once or I think twice or thrice, and it worked very well for you all. But in your courts,
in our courts, I would say, I think that when it comes to the adoption of technology by the courts, you find that the legal profession is one that is conservative and over the years has, across the world, shown to be one of the few professions that is the least adaptive to change. Even though in reality, the law is very dynamic in nature. I would say that with regards to courts in Nigeria, you will find that many courts have actually been very, very quick to embrace technology, especially post-COVID, in a post-COVID world. You find courts like the National Industrial Court, the Federal High Court, inclusive, and courts such as, I think, the Borno State High Court, I believe, that have embraced the use of technology, to speed up the process of administration of justice. We have 36 states and the Federal Capital Territory, so not all states will move at the same pace. But there is no doubt in my mind that technology is needed, to get justice to the common man. With regards to access to information, and that is really what centers around the Kano State situation. You have a situation where under the system of law that we practice, the common law, the role of the judge is to serve as an arbiter who doesn't get involved in the proceedings per se. When a judge gets involved, we say the judge has descended into the square. Yes, it's distinct from the civil law system where the judge actually acts as some sort of prosecutor. So under our system, the judge is quote unquote blind and deaf to everything outside the courtroom. The judge can only act on what the parties bring to the court. There are exceptions, of course, which you can include, under which you can include things like things that are considered to be within the common knowledge of the average person or that are judicially noticed by the court, things in common affairs or public affairs. But beyond the scope of what is known to the public, the judge can only work on the facts presented by the parties. And that is what you find, played out in the Kano, or is playing out in the Kano State situation.
Let's stay a bit with the Kano situation. When a case is of public interest, like, the situation in Kano,
yes,
does the judge owe it to himself and the public, and of course the judicial system, to be more careful when it comes to, ensuring that, you don't have this, conflicting situation. Or is there a deliberate attempt by the, process itself, by the system, the judicial system, to take advantage of these loopholes, not wanting to adapt to change, and that, accuracy that technology would provide?
That's a fantastic question. I agree with you that there's a lot to be said about how the process works in the sense of looking at the development of our democracy today. Now, what exactly do I mean? If you were to look at the types of cases that we had 10, 15, 20, 30 years ago, you'll see that the judiciary has come a very long way. And we're dealing with cases that are more sophisticated in terms of how they test our democracy. Now, well, in this particular case, we have a system where you have the federal high court and a state high court. Both we refer to as courts of concurrent jurisdiction. But in reality, the federal high court has a very special, or it has an enumerated jurisdiction contained in section 251 of the Constitution. Now, these courts are very different, and they are operated and they are manned differently. Their subject matter areas are also very different. So the question really centers around, you know, what should, under what circumstances should certain courts address or take up certain matters.
Right.
And jurisdiction is a concept that is fundamental to any case, or the success or failure of any case. And so it's for want of any other expression, it is important that, in fact, it is said, the Supreme Court has said in many cases that the court should do everything it can to protect and safeguard its jurisdiction. So ordinarily speaking, the rules of jurisdiction, so the rules that govern the court's jurisdiction, the rules of ethics for judicial officers, the code of conduct for judicial officers, and the rules of ethics for legal practitioners actually serve as the guardrails and the guides that ensure that we don't overstep or misuse or abuse the process.
Right, let's move to the situation in Rivers State, this latest development. On May 10, Rivers Court actually gave an order restraining Amewule. The court has said, do not continue to parade yourselves as members of the Rivers State Assembly. That case was determined on May 10, at least the order was given. And
Yes.
then now how do you differentiate that from the interim injunction of today, barring the same Amewule and 24 others from parading themselves as members of the State Assembly? Or even the governor having anything to do with them?
To do with it.
Yeah.
The interesting thing with court decisions is that whenever a court decision is given, in fact, we don't say, whenever a court decision is given, and if you look at, I'll take us back a little bit to the Kano State situation, where the court said, one of the decisions, one of the rulings, the court said the court wasn't sure about whether it had jurisdiction or not, you know, and the court said, okay, it wasn't sure, but still went ahead to make a ruling. Now, in a situation where a court makes a decision or a finding is made, that becomes the law. And so that is what should be executed by the law enforcement agents. Now, in a situation where you have, you know, a conflicting or secondary, or I mean, we might call them conflicting, or where you have an alternative decision or alternative ruling, it actually pollutes or it muddies the waters. Right. It creates problems for everyone. It creates a problem of distrust for the system, for the judiciary. And of course, you find, I was very happy to hear that the president of the Nigerian Bar Association came out very strongly to condemn the Kano situation, and he talked about, and he's called for the investigation of the lawyers involved and the judges involved as well. So in any situation, under no circumstance should the judiciary, either members of the legal profession or judges, put the judiciary or the profession in a position where it comes into disrepute, you know, by members of the public. But the fact of the matter is, at the end of the day, a subsisting ruling of the court is a subsisting ruling of the court.
I like the way you put it, and it's the first time we're getting to see someone use that alternative decision, alternative ruling. And so you want us to play down on the conflicting ruling. Right. And so far it looks like the way it is in law now is more like the military, obey before complaint. But just recently we had a senior advocate of Nigeria, and his opinion is that, well, for those that have been so punished in times past, it will seem as if we're just giving them a slap on the wrist. And that is why sometimes we still see lawyers and even judges perhaps now punitive measures or correcting measures. How would you want us to remedy this and not muddy the water?
So deterrence are generally accepted as a means of correcting bad behavior and then preventing further bad behavior. And that's one of the reasons why we have the Rules of Professional Conduct for Lawyers, 2023, as amended, and the revised Code of Conduct for judges or for judicial officers. Now, the question as to whether deterrence within the system are sufficient or have been sufficient enough to address what you may call an increase, or what may appear to be an uptick or an increase in issues that involve, discipline within the profession.
You like to euphemize it all.
No, trust me, I'm not euphemizing it.
Right.
I'm trying to be as accurate as possible in the description, but I can assure you that there are so many factors at play here. For example, in 1999, you had about 30,000 lawyers in the country, dead and alive, a little below 30,000. Between 1999 and 2019, that number rose to over 110,000. So there's an explosion in the number of legal practitioners. Again, per capita, it's still not as, we don't have enough legal practitioners per capita per citizen. But at the same time, we're talking about an increase in the number of lawyers. We're talking about an increase also in the number of courts and judges. And
Is that worrisome?
Pardon?
Is that worrisome in itself?
No, in itself, it is not worrisome when you think about access to justice. That's why I said per capita, we don't have enough lawyers per citizen. But at the same time, it means that there will be more information about lawyers, and naturally there will be more malfeasance, just by reason of sheer numbers. But without a doubt, there is definitely a need for increased accountability, judicial accountability, and also accountability at the bar. You find situations where in some other jurisdictions, judges who are found to be wanting are actually tried in public.
Right.
In fact, you find hearings on social media, on YouTube, where judges are tried in public and the findings are made known to the public. So in this situation, and I think the NBA president came out clearly, and the Chief Justice of Nigeria has also called on the heads of courts, particularly in the Kano case, to address, call on them for a meeting to address this issue. So I think that there has to be a review in terms of the disciplinary process. Right. But then also we should, when talking about discipline, we're addressing the issue from after it's like closing the stable door after the horse has bolted. Right. There's definitely an issue with regards to the appointment of judges, and I think if we can address the issue from the supply side, we would reduce some of these, demand side problems.
I guess it's a good place to leave it. Folarin Aluko is the former chairman, Nigerian Bar Association, Abuja branch. Thank you for joining us on Newsnight.